and I was waiting. मेरा नंबर कब आएगा, मेरा नंबर कब आएगा, आखिर आ चुका है. कई दफा हम वकील दोनों साइड से प्रिपरेशन करके आते हैं. Since the earlier three speakers have pointed out some shortcomings of this new act, to make it more balanced, I am bound to tend towards the plus sides of this legislation. The object is to have a balanced analysis of the legislation, and therefore, while preparing my initial notes, had it been a batsman at serial number 2, I would have started with the criticism. When I am a second last batsman, then I am bound to look at the performance of the earlier three speakers and then change my style, the points, and then the presentation. And therefore, let us go back and find out what the earlier speakers have expected from the person like me and our session coordinator. Our session coordinator made a reference that we are having some similarity, and that is within the framework of the Advocates Act. He made a reference to section 6 and 7 of the Advocates Act 1961, and that lays down different functions of the State Bar Council, that is under section 6, and functions of the Bar Council of India under section 7. And what is common between section 6 and 7, that is to promote and support the law reforms. And therefore, our session coordinator, Mr. Tripathi, was absolutely correct. No doubt, as a Bar Association of India, which was established prior to the enactment of 1961 Advocate Act, but this topic is essentially with reference to the promotion and support of the law reform. Now somebody may say that, can you call it as a law reform? The answer would be yes. The law reform, it takes some time. We are aware that it is yet to be implemented. We are also aware that in the month of February, a petition came to be filed before the Honorable Supreme Court of India, challenging these all three legislation. And rightly the Supreme Court said that it is a premature petition because the act is yet to be given effect, and therefore there is no any cause of action for coming to the Supreme Court of India at this point of time. That happened in February. Absolutely correct thing. Now the question comes that if we are saying it as a reform, then we will have to change our angle. We will have to change our approach. Let us go back to the law schools. In the law school, if we ask a question to any young lawyer or any young law student, what you would like to become? The person will say that, sir, I wish to conduct 302 matters. I would like to go to the Supreme Court of India and practice there. I wish to practice in the High Court. We are aware that these are the common stereotype answers. Not a single law student you will find who says that, sir, I wish to have my career, or I wish to enter into a legislative draftsman skill to be implemented. Now we are also aware that if you ask to any police personnel, kaha duty karna chahoge, where you want that you should be posted, he or she will say that Thana, because that station in charge is like a chief justice of that particular police station. He will not say that let me go to the local intelligence, let me go to the side branches. On the same line, if you ask to the honorable judges, what you would like to do, the honorable judges will say that I'd like to be the magistrate, so that he is a king of that local area. The honorable judges will not say that I would like to go in the parliament, in that legislative drafting department, or a secretariat to prepare a law. And therefore, if we scrutinize different legislations, then perhaps we can scrutinize this legislation and categorize this as post 2014 legislation. Now you may say that what is this, something new? When we were in the law schools, we were told that there are two groups of the legislation. One group which is a pre-independence, another is a post-independence. Slowly, after 1991, after liberalization, we were told that no. Now post-independence, now there are two more other categories. One is pre-1991 legislation, post-1991 legislation. We are aware about the liberalization approach which was adopted by our country. And now perhaps we will have to scrutinize the legislation and brand it by saying that this legislation is pre-2014 or post-2014. I am sure somebody will criticize this also. But as a student of law and as an impartial analysis, perhaps we will have to consider from that angle also. If we are considering this as a reform, then of course the question will come whether it is a right time to criticize. The answer would be no, because we are yet to test this. Unless this legislation is actively utilized by all of us, I am sure we will not be able to find out the actual drawbacks or the plus. So what exercise we have done? The all earlier three speakers, the learned speakers, have contributed based on the enactment, based on the legislative drafting which has come to us. We all are students of law. We are aware that at least 1 decade, 10 years are required to settle the different permutation combinations which you are going to advance in the court of law. कम से कम 10 साल लगने वाले हैं for the purpose of settling those issues. Now therefore the question comes that whether it is a premature comment on our part. The answer would be no. The comment will have to be treated as a welcoming comment for the purpose of making it more better, more useful, more litigant friendly, more citizen friendly. Unfortunately, what is an apprehension? The Honorable Speaker Amit Desai, senior advocate from my High Court, namely Bombay High Court and the Supreme Court, he said that another 100 years will take place, 100 years will be required to settle the different issues arising out of this. Senior advocate from the Supreme Court, Siddharth Dave, my neighbor, he said, no, 25 long years will be required. I am saying that wait for 10 years. Within 10 years, we will come to know whether this post 2014 was actually reform or whether this post 2014 was in the backward direction. Now, having said about this, now let me go back to the another moot question which was asked by all of us. All of us got that particular three set of the new act. As a young student or young student in the faculty of law, we must have opened it. And after a few minutes, we must have closed this. It's a bare act, उसमें कुछ ज़्यादा नहीं है अंदर. And we must have put it in the bag itself, saying that okay, बाद में पढ़ेंगे, देखेंगे. Now question is going to be whether we are ready to face these different new challenges. Perhaps the answer is no, and therefore such kind of exercise is required. Honorable participants raised certain questions. Whether the police are trained, whether the judges are trained, whether the advocates are trained. I am saying that let us go to the root level. Root level is there is a subject by name civics in the school, or maybe in the law school if you go there, which is that topic which is required to be taught, and perhaps therefore it will be absolutely correct in passing a resolution that instead of 1st of July 2024, defer it by some more time so that this topic can be taught in the law school. This topic can be included in the school education. This topic can be included in the different judges training academy. This topic can be included in the administrative training academies, so that the entire implementation will be a citizen friendly. There is an apprehension which I must say. The apprehension is this, that this is going to increase number of litigation. Number one, the litigation at appellate level. Number two, litigation at a revisional level. Number three, litigation at the Honorable High Court and the Supreme Court level. Why? Because we apprehend that the Honorable judges, the police personnel, and perhaps the lawyers are not well trained, lawyers are not educated how these provisions are required to be implemented. And therefore, if we start from 1st of July, as rightly asked by our President Prashant, what is going to happen on 1st of July? 1st of July, there will be a flood of different types of the litigation. Therefore, the question comes, are we prepared for this? The answer will be no. Having said about this, now the question comes that whether we have missed an opportunity, the opportunity to include something, and what was that inclusion which ought to have been done. I'll have to make a reference about that. There are some provisions which are duplicated. The earlier speaker, the member of parliament, he made a reference about some provisions which are duplicate in nature or overlapping. So that was an opportunity perhaps which can be cured before 1st of July. To give an illustration with reference to the adulteration in the food or drink, there is a provision in the Indian Penal Code. I am referring about the earlier one, 272, 273. If we go back to Food Safety and Security Act 2006, there is a section 59 which is virtually overlapping. These are the examples which are already in the field. We will have to correlate these overlapping and make an appeal that please remove such overlapping. For example, the Drugs and Medicine Act 1940 section 27 is overlapping with section 274 and 275 of the Indian Penal Code, which is continued even in the new act. So therefore, about the food adulteration of the drinks or the food, the provision is there. Like Drugs and Cosmetic Act, the provision interlap even now. If we go back, if we go to the further, the 374, unlawful compulsory labor, like a bonded labor, the provision is there, 374 of the Indian Penal Code, which is continued even under the new act. And what is the corresponding act? The Bonded Labor System in bracket Abolition Act 1976. So again overlapping is there. So at least I can give you 5 or 6 such overlappings which can be cleared before 1st of July. Otherwise, as the earlier 3 speakers said, that because of this, the discretionary power, whether exercised in this manner or that manner, there will be a rise of litigation. Whether this act will prevail or that act will prevail, there will be a further litigation. On this line, you will find, with reference to the rash and negligent driving, and Indian Penal Code 279, we are aware. But Motor Vehicle Act 1988, section 184, again that provision is continued. The same provision of 279 is continued in this Nyaya Sanhita. So therefore, at least 5 or 6 different things are there in respect of which we lost an opportunity, is a humble opinion. Because this could have been cleared. Apart from that, you will find that there are certain omissions which have been made. Those omissions are specifically with reference to the particular topic. Now, those omissions, whether right or wrong, the time will decide, because those omissions are yet to be tested. Like adultery. The earlier speaker made a small presentation in which the adultery word was there. 497 of the IPC. In the new act, it is not there, but there is a reference under 498A. 498, not A, 498. So you will find that the adultery, which was a offence under the old Indian Penal Code, is now done away and removed under the new Sanhita. Unnatural intercourse, section 377 of the IPC. We are aware that with reference to decriminalization of those consensual relationship, the judgment came from the Honorable Supreme Court of India. But under the new act, you will find the rape on the male or intercourse with the animal. These are the things for which now there is no offence. As a result of that, despite the new act, there is still a vacuum with reference to certain types of the offences. Now you will also find the molestation of a woman, section 509 of the Indian Penal Code, that has been omitted. Now 509, whether correct or incorrect, that is something different argument. But the law has been made, the new Sanhita says that the priority is given to women and children. Separate groupism has been made with reference to those offences. Despite that, this 509 is now omitted. Whether it is correct or incorrect, time will decide. You will find that lurking house trespass at night, 444 of the Indian Penal Code, or 446 house breaking at night, those have been removed. Now whether it is correct or incorrect, time will decide. You will find 309 has been removed, attempt to commit suicide. Now there are several such provisions which we can make a list. Now with reference to the weights and measures or Indian coins, there were several such sections which have been removed from the new Sanhita, like section 264 to 267 of the IPC. Those were with reference to the weights and measure. Likewise, with reference to the coins, Indian coins, 236 to 238 of the Indian Penal Code. Now the time will tell us whether it is correct or an incorrect decision which has been made. Having said about this, now the time has come to make a reference about certain new concepts which have been introduced. The young participant from the Odisha made a reference, and that question was asked to the learned MP, member of the parliament, and at that point of time, the honorable chairperson will recollect, I said that two speakers are yet to start their batting and the question has come, and that was about the theories of the punishment. Let us go back to the schools. In the law school, we were taught about the theories of the punishment, and in the Indian context, we are aware that deterrent theory of the punishment was the only theory which has been implemented all throughout. From 1860 till today, most of the section you will find that deterrent theory of punishment has been touched. The reformative theory, of which some sections may be having some reference, was still not implemented successfully in the Indian context. Now we can say that with reference to introduction of some more reformative angles, this theory may get a further push in the Indian context. This is with reference to that community service. The Honorable Speaker, Senior Advocate from the Supreme Court, Mr. Dave, asked a pinpointed question whether community service is defined under the new act. Of course, the answer is no. But the fact remains that this is a enabling provision which is available to the Honorable Judge. The Judge will utilize that. The Judge may take into consideration the mitigating circumstances. The Judge may pass appropriate further order. Now something good is the organized crime, terrorist act, these have been defined under the new act. There has been a demand for years together saying that why do you have different new legislations? Why don't you incorporate those provisions in the mainstream, namely the penal code, like when Makoka came at that point of time, Tada, Puta, why do you need that? And the logic which was cited before all of us was this, that because of the complexities of the offences, there is a need for the further legislation. The further legislation which is stringent, and therefore the legislations were introduced. Now this is something new which has been attempted to, namely now organized crime has been defined. Now terrorist act has been defined. On the same line you will find with reference to the transgender, there is some reference in the new act. About the gender neutrality also, some provisions are there, though it has been a demand for years together. Having said about this, now the time comes to find out whether we are really speaking ready to meet these challenges. As I said that this enactment has to be a citizen-centric enactment. The young lawyer asked a question about the victims. Somebody may say that no, there is another different angle. But the fact remains that as on today, the new enactment has to be a citizen-centric. And the question before all of us is this, whether this act is going to achieve that particular target. Now, having said about this, as I said that we are student of law, and in view of that, I am also open for correction. And as I said that Since all earlier my three speakers, they said that they started by criticizing this act, therefore I was required to change my presentation. I was given 20 minutes, 20 minutes, 13 seconds, 14 seconds, 15 seconds. Now it's a time to stop, and I am open for the question and answer session also. Thank you for the opportunity. Thank you once again.